Hey class, excited to present the speaker that we have today that will shine a light on a lot of the issues that many of you are having with the opacity of so many of these securities laws that are touching blockchain. And it's hard to find a lawyer that's steeped in exactly the type of laws that are facing emerging technologies, that are facing distributed ledger technologies, and the whole gamut that people are trying to build businesses around. So I was thrilled that Patrick Daugherty Esquire would come on the call with me today because I'd heard him on other communities that were looking for experts on exactly these topics. And has a full calendar going around the country and collaborating with other universities in addition to his faculty work at Cornell Law School. So pleased to have him as part of our module here in week 5 at UCLA. So Patrick, appreciate you being on the call. How are you today?
Rob, I'm terrific. Thank you. And really, it's the easiest sell in the world to enlist me to speak to your class because I just have tremendous respect for UCLA. It's a global alpha institution. And so the chance to talk to your students really around the world is something I would not want to miss. Thank you for having me. I am going to speak about United States federal regulation of crypto assets. That's a discrete topic. I'm going to leave the rest of the subject to Rob and other guests that he may have in your class. This is all law today, and it's all United States federal law that we will discuss. I'll begin with my short overview of the industry, what it looks like, some dynamics there, but won't spend long there. I will then cover SEC regulation, CFTC regulation, Treasury FinCEN and OFAC regulation. So we've got the securities laws, commodities and derivatives, banking law. Those are the 3 main areas. Not covered, but worth noting, bear this in mind, the IRS, the tax authority in the US, also has a role in the crypto asset industry. We're just not covering it today. And also note this, US President Biden issued an executive order on ensuring responsible development of digital assets, not quite a year ago. And in that executive order, he calls for a whole of government approach, that's what they call it, to addressing the risks and harnessing the potential benefits of digital assets and blockchain tech. The whole of government approach signifies that, sure, the SEC, the CFTC, and the Treasury are involved in the IRS, but everyone else is involved also, and you had better believe that that is the case. We just can't cover it all today. We're hitting on the main points here. So we'll begin with my view of the industry. Very briefly, and you might have seen this already. This is the Bitcoin white paper that was published 14 years ago. I'm tempted to read the abstract aloud to you. Jack Dorsey calls it poetry. But instead, I'll just touch on the core concepts and the zeitgeist of Bitcoin. Satoshi discovered and explained that cryptography, when combined with a peer-to-peer network, makes it possible for one party to transfer an asset to another party without using a trusted financial institution, a bank, to prevent double spending. We use banks, among other things, to prevent double spending. You know what double spending is, right? And if you don't, double spending is the reason why the merchant that you're buying something from, why the merchant calls your bank before she lets you leave the store with valuable merchandise, having paid for it with a personal check. The merchant wants to make sure you haven't spent that money twice. It's double spending. So using the Bitcoin blockchain, there's no need to trust a financial institution to prevent double spending because the other participants on the blockchain, the Bitcoin miners, verify the legitimacy of each transaction. Likewise, there's no essential role for the government in these transfers. It's all what lawyers call private ordering. This is why libertarians are enthusiastic about crypto assets. And it's what blockchain engineers mean when they say things like code is law. When you challenge them about that, they will also say things like this. Well, you can trust banks and the government if you want to. For my part, I will trust computer science and math. So in the beginning, it was all about trust, or rather distrust. First, distrust of financial institutions, especially big banks, but also and concurrently distrust of the government, especially big governments, the state. Why? And why then? Remember, this happened 14 years ago. Well, the landscape in 2008 displayed big banks failing in the US and in Europe, Lehman Brothers, Bear Stearns, Merrill Lynch, many others. And the state, big government, was bailing them out. It was the global financial crisis. It was managed by bankers and politicians whose confederates had created the crisis and had gotten rich in the process. They were using their political power to force taxpayers in the United States, particularly, to bail them out of the disaster. For libertarians, this was very bad. This was the winter of discontent. And from their perspective, it has only gotten worse since then. Well, how bad? So Pomp is Anthony Pompliano. Follow him on Twitter if you'd like. He notes I'm recording this with Rob in January, in mid-January, that national debt is now more than $31 trillion. He says that's madness. The debt is not identical to spending, but the debt is driven by spending. U.S. spending levels have likewise turned up very significantly in recent years. He says that's madness. And Elon Musk replies, more than triple that when you add in Social Security, Medicare, and government pension obligations. In other words, it's a whole lot worse than you're saying, Pomp. So this is the kind of view that is expressed by people who have a fondness for hard money. Bitcoin enthusiasts have a fondness for hard money. Pomp is certainly one of them. Elon Musk has sort of come and go for that. But by hard money, we mean money that is capped and that is not inflated. The supply is not inflated, and certainly because the inflation caused the depreciation of the value of the currency. So that's where the enthusiasm for Bitcoin comes from, or part of it anyway. Now, sometimes you'll hear this, crypto is too complicated. Crypto is like a religion. And I wonder about that. I'm showing you a map here of US dollar flows.
And could you just make that just a little bit bigger? I don't think it's quite.
And you won't be, and you're not going to be able to read it very well. Let me try. I don't know if this will help. You're not going to be able to read it, but I'm giving you the source.
Okay, that's fine.
In fact, the inability to read it is partly my point. It is this. This is a picture in which the New York Fed explains the US dollar market. The Fed is on the left, the dollar funding market's on the right. I've looked at this several times and I think I understand most of it, but I've been in finance for 40 years and I'm 66 years old. I think very few people who use US dollars, which would be every American citizen and many people around the world, very few people actually understand US dollar flows and the Fed's role in money creation and the Treasury's role and the government's role in spending. They don't really understand it. Here's a picture of it, but here's my point. Why do they use US dollars anyway? Well, because they trust that this is going to work out okay. They trust that the Fed will play a proper role in keeping the dollar stable, so that it'll be a useful form of currency on a go-forward basis. They trust it. In other words, they don't actually learn this chart any more than they learn how crypto assets work. But they trust the US dollar. And why do they do that? Well, because they've been taught to do so. They're literally taught to trust the US government and its institutions, including the Fed, from childhood onward. And I could give you lots of samples of that, but I won't. My point is that at the root of every kind of currency is some degree of trust, some trust in the government and in big banks. And for them, US dollars and other fiat currencies are the answer for everything. Others have some doubt about the government and central banks. And for them, crypto assets, which depend upon algorithms and math and hard caps and computer science, for them, that's a more reliable answer, or at least part of the answer. I want to point out that the banks do have influence over the political process. That's not a new thing. Here is an illustration of the Locomotive Act of 1865 as enacted in Parliament in London. In 1865, Parliament enacted a law that, according to one writer, effectively stopped innovation in powered road transport in Britain for over a quarter of a century. The Locomotive Act of 1865 became known as the Red Flag Act because it required, listen to this, that any self-propelled road vehicle had to be preceded by a person walking at least 60 yards ahead, carrying a red flag. Now, how did this law get enacted? Well, it followed intense lobbying by whom? By horse-drawn carriage operators and by the public railway industry. The horse-drawn carriage operators wanted to kill it altogether. The public railway industry was actually, they were in favor of automobiles as long as they were used to drop off passengers at railway stations. That was okay. So, and in a rather severe response to the dangers posed by motor vehicles, the Red Flag Act also brought into force the world's first road speed limit, which was 4 miles per hour in the country, 2 miles per hour in towns. So think about that, 2 miles per hour in towns. In other words, automobiles are permitted as long as you cannot move them faster than a human being can walk. Okay, so as motoring innovation gathered pace, this started to look increasingly absurd, and it was campaigned against, and was finally repealed in 1896, when the Locomotives on Highways Act scrapped the flag and raised the speed limit to 14 miles per hour. That same year, by the way, 1896, in Pennsylvania, A law was proposed to require all drivers of horseless carriages upon chance encounters with livestock to immediately stop the vehicle, immediately and as rapidly as possible disassemble the automobile. And because it would scare the livestock, conceal out of sight all the components of the automobile until the livestock are sufficiently pacified. That was the Pennsylvania law that was proposed. Now, the point of this illustration is this: vested interests use their political power to defend their turf from encroachment. I call this the iron law of incumbency. Incumbents do everything within their power to maximize the value of their incumbency. Never is this more true than when the emergence of a new technology threatens to disrupt the status quo. Here's another illustration for that point. Just this month in Davos, the most powerful banker in the world gave an interview in which he opined that Bitcoin is a, quote, hyped up fraud, close quote. That was Jamie Dimon right there. The crypto industry shrugged it off because the banking industry it's starting to come around, but has been the mortal enemy of decentralized finance. From a crypto industry perspective, Jamie Dimon is not much different than a horse and buggy salesman who lobbies the state legislature to block high-speed passenger use of automobiles that move faster than 2 miles an hour. Or a more modern example, a taxi medallion owner who lobbies an airport commission to block the use of rideshare vehicles at the airport. Now, in both cases, they claim to be doing this for the public. You see, Jamie's preventing the public from buying a fraud, and the taxi medallion owners, those Lyft drivers, they're unreliable. But look, everyone knows there's self-interest involved. These are self-interested economic actors who are presenting it all as if they were public-minded citizens. And from a crypto perspective, it's not going to work. That asteroid is going to hit you, Jamie, and it is actually more dangerous than you think. So that's my background. Here's the universe of crypto assets, as I conceive it. There are 3 basic categories. You have cryptocurrencies like Bitcoin, Ether, AVAX, Solana. These are aspirational currencies. They aspire to have a general use, but in all fairness to Jamie Dimon and other critics, they aren't used much yet outside the online domain. But they aspire to be similar to or used as if they were the US dollar, the pound sterling, the euro, the yen, yuan. So they're aspirational currencies, and they certainly exhibit significant volatility. But I'll tell you this, that's a feature of all new currencies, not just cryptocurrencies. If you study this over the centuries, as I have, every currency is volatile until its use broadens out and Moore's law takes over, and you have lower volatility. The second category are tokens. Sometimes these are all grouped together as tokens. Tokens are designed to have specific uses, and they are in fact used as intended. Examples would include, in the analog world, subway tokens or movie tickets. Those are usually digital now too, but in the analog world, sometimes they're actually a piece of metal or a piece of paper. These are sometimes called utility tokens. There are thousands of them, thousands, but only 3 have been approved by the SEC. So beware of them. And if you're in the design business, be very careful how you design them. Stable coins would be the third category. They're a proxy for the US dollar or another fiat currency. They serve as a bridge from fiat to crypto and back, but they can also be used in commerce. They are used in remittances in much of the world. For example, use stable coins to send money home. These are the ones with the largest market caps: Tether, USD Coin, Binance. Endogenous stable coins are a subcategory here, like Terra and Luna. I expect those to be banned, and that's probably a good idea. There are other kinds of crypto assets. They're mentioned in the footnote: securities tokens, CBDCs, non-fungible tokens, NFTs. I could talk for an hour or more about each of those, and I won't because we've only got 45 minutes. But they are on the chart. They're just less important in my view. Who owns crypto assets? Well, 40 million US adults. More adults now own crypto assets than have bank CDs. Think about that. Men, millennials, and higher earners, especially baby boomers, people in my age category, least likely of all. Crypto ownership very high in Latin America. Also notice in LATAM, inflation is high, capital flight is high, trust in banks and governments is low. In the US, we're relatively spoiled because we have a relatively stable government and we have pretty high trust in banks and governments. And we do have inflation, but it's only maybe 6 to 8% a year. In Argentina, it's somewhere between 50 and 100% per year. If you're an Argentinian, which do you prefer? Holding a volatile asset like Bitcoin or holding your own fiat currency, which is guaranteed to lose about half of its value every year? When you ask the question that way, you understand why Argentinians buy Bitcoin. And that's true in other places around the world. I could speak some more about this, but let's move on. We're getting into the law now. This is a very famous case, the Howey case in the United States, 1946. Thank God, it's 10 years before I was born. Here's what you need to know about this case. It's all about orange groves in Florida. Around Orlando, there was a company called Howey in the Hills that would offer the following contract. They said, you can buy, give me some money, and I'll give you a piece of an orange grove. But bearing in mind that you, the investor, you probably live in New Jersey or Connecticut or Chicago, you can't tend to that orange grove yourself. Don't worry, I'll couple it with a contract to cultivate, market, and remit the proceeds from orange sales to you. And so, people who like the Florida citrus industry would say, yeah, that's okay, that might be a good deal. So Howey in the Hills raised money that way. They got sued by the SEC. The SEC said, you're selling securities. The owner of Howey in the Hills said, what are you talking about? I'm selling oranges. It went to the Supreme Court of the United States, which ruled that these were in fact securities, not oranges. But notice carefully, it wasn't the oranges that were the securities. Oranges are not securities. Write that down. I'm serious, because the SEC keeps making this mistake. Oranges are not securities. The oranges plus the contract were a security. And specifically, they were an investment contract. Remember this, you can't have an investment contract unless you have a contract. But if you have here's how you have an investment contract. You have an agreement, contract, or scheme between one party. We'll call that party the issuer. And by the way, make this note. If you can't identify the issuer, you probably don't have a security, because you can only have a contract with an issuer. So you have to have an agreement, contract, or scheme involving an investment of money in a common enterprise with an expectation of profit. What profit? Well, the money I'm going to get out of this deal, of course, derived solely from the efforts of others. Whose efforts? Well, the Howey Company in Florida, because they were going to cultivate, market and market the oranges and sell them and remit the net proceeds as profits. I put brackets around some of these words because there have been something like 200 Howey cases since Howey. And we're not going to cover them all. We're only going to cover this one. But these are glosses that were worked into the Howey definition over time. So, an investment of money. Well, over time, that's come to mean really any kind of value. For sure, you could buy a crypto asset with another crypto asset, and that would count as an investment of money. But you could also put your own labor into it. That would count as value too. If you work for the token, that's an investment of value, even if you're not investing money. The common enterprise could be either horizontal, meaning among other investors, or vertical, meaning between the investor and the promoter, or both. And there's a split in the circuits in the US. That means courts disagree. Kind of depends on where you are in the United States, which rule is applied. Makes it harder. And the expectation of profit, probably needs to be primarily for profit, because there might be some incidental consumption use. But if you're mainly expecting to make money by doing this rather than to consume the item, then, if you were consuming the oranges, for example, that would not be an investment contract. But you weren't. They were going to be, marketed and sold. So you were expecting profit, not consumption. That element's present. And then finally, it has to be derived solely or primarily from the efforts of others, and not just any efforts. They have to be the managerial or entrepreneurial efforts, the ones that really matter, as opposed to administrative efforts, which don't matter so much. That's the Howey test that everyone talks about. The Dow report was the first incursion of the SEC into digital assets. The Dow, this was in 2017, the Dow was a decentralized autonomous organization, the first of many, actually, a virtual organization embodied in code and executed on blockchain. In this particular case, Dow token holders would share in the earnings from projects as a return on their investments. They got a split. They got a cut of the action. Also, they could sell their tokens on secondary trading platforms. That's commonly done today. It was the Dow sponsors who determined the Dow governance rules. The token holders relied upon the Dow sponsors and upon curators to whitelist projects for voting. That was a problem. Those efforts were what the SEC called the undeniably significant ones. Putting people in charge to determine which DAOs would be voting upon, curating in that way, is reliance on the efforts of others, managerial and entrepreneurial efforts. So this was a security to the SEC, with some pretty significant consequences. For example, the Securities Act of 1933 applied, with the result that the tokens were illegally offered, because if that law applies, that they have to either be registered with the SEC or you have to have a valid exemption, and neither one of those was in place. So that was illegal. Also, the platforms that matched orders from multiple parties to buy and sell tokens for execution. Guess what? That was an illegal securities exchange. It wasn't registered as an exchange like the New York Stock Exchange. There was no exemption, so it was illegal. There were funds that bought these tokens. Those funds were not registered as mutual funds under the Investment Company Act. So guess what? Those were illegal mutual funds. And the persons who advised others to buy these tokens, they weren't registered as investment advisors. So guess what? That was illegal under the Investment Advisors Act of 1940. So here's the thing you need to know. If it's a security, it's a security for all these purposes. You don't have one violation, you have several. And if it's not a security, then you don't have any of these problems. But if you do have a problem, you have a very big problem, not a small one. The Dow report was a shot across the bow. It was an exercise of soft power. The SEC didn't actually require anyone to pay a fine. In that case, they just said, please don't do it again. But there was a lot of disagreement with the SEC, which continues, and there was scofflaws as well, who just said, well, that's what they say, we're going to keep doing it. And so there's been a lot of enforcement after that. More than 100 cases have been brought by the SEC since. Here's a few of them. Just last month, the library case. You can think of library as the Web3 alternative to YouTube. If YouTube is Web 2, the Web3 alternative to that was library. It was held to be a securities offering. Everyone's waiting for the Ripple Labs results, which will probably come in the next 2, 3, 4 months. That's a very big case in New York. There are other ways to be a security. I'm going to go quickly through this because I want to hit other topics. But I mentioned it could be an investment contract. That's true. And if it is, it's a security. But there are other kinds of securities. Notes are securities. So there's a famous case called Reeves that goes to the U.S. Supreme Court, not in 1946, but 1990. That's pretty old too. Justice Marshall, who's now passed away. But so here are the rules. If you have a promissory note, it is a security. And people who are in banking will be surprised to hear this, or maybe not. But notes are securities unless they fit in a category that's already understood to be not a security. There are some. And most banking notes, most promissory notes given in commercial transactions fit in that category. So they are not securities. You're not violating the law by doing commercial banking in a bank. But other kinds of notes can be securities. These are the standards you look at. 1, 2, 3, and 4, 4. Is there some factor, such as the existence of another regulatory scheme, that reduces the risk of the investment, thereby rendering application of the securities laws unnecessary? Well, the Reeves notes were uncollateralized and uninsured. So they did not have the benefit of banking regulation, the benefit. And therefore, they were held to be notes that are securities. Notes that are issued by banks are subject to banking regulation. This is one of the reasons, and there are others, why they are not securities, because it would be redundant to apply the securities laws to them. They're already regulated by the banking regulators. But there are a lot of platforms out there that engage in crypto asset lend programs. They are not regulated by the banking regulators. They are not regulated by the SEC either. Coinbase was told to abandon their planned launch for a lend program, basically a gunpoint. They said, if you launch tomorrow, we're going to sue you. They got 24 hours notice to abandon it. That was aggressive on the SEC's part. BlockFi agreed to pay $100 million fine just a year ago. BlockFi is bankrupt today. Voyager had a lend program. It's bankrupt today. Celsius had a lend program. It's bankrupt today. Do you see a theme here? Nexo just last week agreed to pay a $45 million fine and to exit the US market. These are lend programs of centralized crypto institutions. They're probably all illegal securities offerings. And so Coinbase doesn't do it, and the others are either bankrupt or leaving the US. Talk briefly about the CFTC. The Commodity Exchange Act of 1936 and the rules under it regulate the trading of commodities like agricultural products, for example, corn, wheat, pork bellies, just to name 3 that we know here in the Midwest where I am, but also futures and swaps. Virtually everything is a commodity. For example, oil and gold, those are commodities. But that doesn't mean it's a security. Over time, the SEC and the CFTC have sometimes jousted with one another as to whether or not an investment was a commodity on the one hand or a security on the other. This has been worked out. There was a famous accord between 2 chairmen of these agencies in 1982. Swaps were added under Dodd-Frank. Here's what you need to know about commodities, futures, and swaps. So trading of futures and swaps is much more highly regulated than spot market trading. Spot market trading regulation is generally limited to bans on fraud and manipulation. In other words, you can't lie to people in spot market trading, and you can't manipulate the market. But that's essentially the only rules you have to follow. Futures and swaps regulation is much more extensive. I won't get into that, but I'll point this out. Futures and swaps can only be sold to the public on registered markets like the Chicago Merc. And when I say the public, I mean anyone who's not really rich. I mean, as in a decamillionaire. If your net worth is less than 10 million, if you have less than $10 million in financial assets, you're not allowed to buy futures and swaps except on a registered exchange. So then it becomes very important in crypto, when is it in the spot market and when is it a future? And the answer is, well, basically, how quickly does it settle? If it settles in less than 28 days, it's spot. If it takes longer than that, it's a future. So people try to make sure these contracts are 28 days and less in order to avoid the illegality of having an unregistered off-exchange future or swap. There's a third body of law I promised to cover. That is money service regulation, money service business, and money transmission regulation. There are two elements of this. One is that I'll give it to you in a couple different dimensions. One is it's both state and federal. There's no preemption of state law here. So if you're in the money service business, you have to register with the feds. You also have to register in the states where you do this business. You might have to register in 51 states or more. So you need to have a system of policies, procedures, and internal controls, a designated Bank Secrecy Act officer. Bank Secrecy Act is for money service business compliance. You have to have appropriate training for these compliance personnel and appropriate independent testing for them. By the way, there are non-US laws that apply in this area too. They're at least as severe as the US, and in some cases more severe. The Financial Action Task Force has made sure of that. I will give you a couple more points of guidance here. This is the Treasury FinCEN guidance. Treasury FinCEN is a bureau of the US Department of the Treasury whose job it is to prevent and police money laundering. That is its job. Its job is to make sure that currencies are not used, insofar as the US is concerned, to finance terrorists, to finance mobsters, to finance child pornographers, and to finance enemies of the state. Frankly, to make sure it's not used, money is not used to finance the government of Iran or Hezbollah. So that's a serious job. There's guidance from Treasury FinCEN about crypto assets. Here are the basic rules. I'll read them to you. A person wherever located, doing business, whether or not regularly, wholly or in substantial part within the United States, who operates directly and indirectly as a money transmitter, that is a money service business. Notice, wherever you're located, if you do a substantial part of business within the United States, and it's a money transmission business, you're a money service business, you're required to register. They will come after you. There was an indictment in the Eastern District of New York just last week in January of an offshore entity, non-US entity, that was engaged in crypto asset transactions significantly involving the United States. They were indicted. And they will likely go to prison. These are federal crimes. These are not just federal offenses. These are crimes. If you violate Treasury FinCEN's laws, you don't get a phone call from the SEC, which is stern. You get one from the U.S. attorney, who might just put you in handcuffs and pull you downtown. They're federal offenses, which are criminal offenses. So what's it mean to be a money transmitter? Well, a person who accepts currency, meaning legal tender, or other value that substitutes for currency, that includes crypto assets, accept crypto assets from one person and transmit value to another location or another person by any means. Is Bitcoin mining money transmission services? The answer is no in most cases. How about Ether staking? The answer is no in most cases, but not in every case. You might need to consult a lawyer about that. By the way, banks, brokerages, introducing brokers for futures firms, mutual funds, these are all exempt. But not because they can get away with this. They're exempt from these laws because they're covered by other laws. They're covered by banking laws that say you cannot do this. They're covered by securities laws that say you cannot do this. These laws, the FinCEN laws, these cover the entities that are not banks, that are not securities brokerage firms. Who's a person subject to these rules? Well, it could be just about anybody. It could even be an unincorporated association. It could be a member of a DAO. I could talk for hours about that, but we don't have hours. There are exclusions. Generally, exchangers and administrators are within the definition and users are outside of it. So someone who uses crypto assets to buy goods and services on his own behalf, that person is not a money transmitter because you're a crypto asset user. You're a transmitter if you exchange or if you administer. I told you there are criminal sanctions. You can go to 5 years for each offense. That's serious. Now, does Treasury FinCEN do anything for safety and soundness? No, it does not. Does it do anything to protect customers from fraud or manipulation? No, it does not. To assure market integrity? No, that's not its job. So being regulated by Treasury FinCEN does not mean your token is not a security. It probably is a security under Reeves. And that's why all these that's why all these lend programs are in trouble, because they say, well, we're regulated by FinCEN, and the SEC said, who cares? FinCEN is not bank regulation. It doesn't regulate you for safety and soundness or customer protection or market integrity. So your loans are securities. OFAC, it's the final thing I want to cover.
is another Treasury Department. OFAC is the Office of Foreign Assets Control. OFAC maintains a specially designated nationals and blocked persons list. Who's on that list? Bad people are on that list. Known narco traffickers are on that list. I'm pretty sure Vladimir Putin's on that list. People who, for one reason or another, U.S. persons are not allowed to do business with, period. Just not allowed to do business with them. If you run a crypto exchange, you have to be very attentive to who you're doing business with. You dare not do business with somebody on this list. Kraken, I'll give you an example. And Kraken is a very well-regarded crypto exchange with an excellent legal department and compliance staff. You know, Kraken just paid an enormous fine. I want to say $50 million. I could be wrong. Maybe not that big. I don't remember. But they paid a huge fine because they had accidentally done business with people out of Iran. And that came to the government's attention. So this is the point of AML KYC. This is the point of being a money center service business. You have to pay very close attention to who your contraparties are, because if they're on the list, that's a crime. There's some samples here. Tornado Cash is a very famous one. But I want to stick to the script and not overstay my welcome. I'll just point out for those of you who will be engaging in transactions in the crypto industry. For example, suppose you're going to engage in a transaction with a crypto exchange. There are some provisions you might want in your contract that cover money transmission and sanctions compliance. Here's a few contract provisions. You're going to want the exchange to represent and warrant to you that it complies with all the laws applicable to anti-money laundering and the financing of terrorism and anti-corruption under all applicable laws. You're going to want them to represent and warrant and promise that they're not doing business in Cuba, Iran, North Korea, Sudan, Syria, the Crimean region, etc., because those are sanctioned countries and sanctioned persons. By the way, if they do that, that's a bad thing, but you at least want them to represent to you that they didn't do it. You did everything you could to make sure they didn't do it. You at least got representation authorities from them. There's some other examples here, but you get the picture. You can protect yourself in dealing with financial institutions that engage in the crypto markets by getting contact protection. And if you go to work for such a bank, that's great, terrific. But you're gonna end up giving these kinds of assurances, and you'll want to get this kind of comfort from your customers too. You're going to want your customers to say that they are not sanctioned persons and that they do not do business with terrorists and so forth. Those provisions go in both directions. Rob, I could go on and on because I love this and there's so much to cover. But you teach your class in segments, and there's only so much that students can be expected to sit through in one day. So I'm going to say I'm done with it now. I'm going to wish everyone all the best in the rest of the course of study here and as they further their careers. If this is useful to you, you can find me on LinkedIn. You can find me on Twitter. Feel free to ping me there. I publish a lot of material there. And I wish you all the best. Much respect for UCLA and for you, Rob, and all the best to your students. If you have any questions, happy to take them, and also fine with just turning the controls over to you in the class.
Yeah, I might just ask you three just to wrap a bow on these incredible slides that deeply double-clicked on a lot of these issues that are completely opaque. So yeah, you probably, I know you saw how like Wyoming is taking the lead on trying to create an entity that is DAO. Yes. So you're saying that, let's say that a DAO was spun up and the Lazarus Group joined as one of the DAO members. Just the association is bad enough that that's the reason why they have to do the KYC AML if they want like a banking account or those types of considerations to make sure that all parties to a DAO are at least known to regulators, right?
That's right. And that sort of thing has been known to happen. A couple of my slides refer to the Lazarus Group, which is the Lazarus Group is North Korean government-sponsored cybercrime. Basically, the Lazarus Group goes around the world hacking crypto assets and hacking banks and brokerages and stealing the assets there, and then they want to fence it through crypto exchanges if they can. So that's the sensitivity. And it's state-sponsored. I mean, it's tantamount to the North Korean government itself doing that.
Second, what do you? Many people feel comfortable under the accredited investor standard.
Yes.
So they'll stake, and they feel like because they've either self-certified or very lightly certified that they're covered. You're thinking that it may be that just qualified purchasers or that really high watermark is going to be the one that's ultimately used. Do you feel strongly across the board on that?
I think for futures and swaps, it's appropriate to have a higher standard, because of the leverage in those contracts and the complexity of those contracts. Those are mainly institutional contracts. An exception would be the ones that are traded on major exchanges that are very highly regulated and are well known and followed closely. But And there the standards very high. You have to be an East, you have to be, like I said, a decamillionaire. But lower standards are for private placements, including private token offerings. The accredited investor standard is the correct standards, and I think it's the correct one and it's the appropriate one. And of course, for those crypto assets that are in the public domain, such as Bitcoin, Ether, AVAX, Solana, well, there are many in the public domain. You don't need to be an accredited investor for that. Any civilian can buy and sell them. I don't give investment advice. If I did, I would say, don't put in more than you can afford to lose, and don't put in more than 1, 2, 3% of your portfolio in any event, just to diversify away from that. I don't give investment advice, but if I did, it would be along those lines. Not a smart thing to put everything you've got into a crypto asset, not because it's a scam, but because it's highly volatile. And you need to be able to access capital occasionally. So that's my thought about that.
Do you have a strong feeling over whether the CFTC or SEC will ultimately get all umbrella coverage for crypto, or is it just too complicated, too fragmented to do that?
I hope it's the CFTC. I suspect it'll be shared. I also suspect the Treasury will have a role with respect to stablecoins. And that makes sense to me because I believe stablecoins probably will be induced, either directed or induced, lured into a federally insured format, either as national banks or as state chartered banks with access to the Fed window. And I think that's the lure to get them in. And the price of that will be bank regulation. But I think bank regulation of stablecoins is appropriate. I wouldn't want to force them to do that, but I would offer them the opportunity and incentives to do that. And there are proposals out there to do that now. But for the vast majority of crypto assets, I hope it goes to the CFTC because they understand this field better and they have a lighter touch. They're, in my point of view, friendlier to capitalists than the SEC has ever been. But I think that's going to be fought bitterly hard on Capitol Hill, and there'll be a lot of lobbying by the SEC's chairman to retain as much jurisdiction for himself as he can. And that's just the way things are going in Washington.